According to the Texas Code of Criminal Procedure, bail is the security given by a defendant so that he or she will appear and answer for the criminal charges brought against him or her before the proper court. For the purposes of the CCP, bail includes a bail bond or a personal bond. Let's take a moment to make a clarification. There are two words typically used to indicate the security, usually money, given by a defendant after they are arrested so they can leave jail and show up to court on their own. These words are bail and bond. Most people, particularly the public, use the words interchangeably, but try to think of it this way. Bail is the security, again, usually money that you hand over, and bond is your word or the promise you give to show up for court. So ever so distinctly, when you are permitted to leave jail after being arrested but before your case is adjudicated, you give both bail and bond, money and promise to appear. In some low-level offenses, a defendant may be given a personal recognizance bond. That means they need not provide any money. They only promise to show up for court. Let's take a step even further back so that we can understand everything the Code of Criminal Procedure refers to in terms of bail. Several things are going to happen after a person is arrested and booked into jail for an offense. First, if the offense is a B misdemeanor or higher, the defendant will go in front of a magistrate for an initial appearance. These are usually called a probable cause hearing or a show cause hearing and are conducted usually at least once a day, perhaps more often depending upon the county. They may be conducted by CCTV or in a courtroom or other location inside the jail. During this hearing, the judge will review the arresting officer's probable cause statement. If the magistrate finds the facts and circumstances given for the arrest rise to the level of probable cause, the magistrate will advise the defendant of the crime he or she is charged with, advise them of their rights, ask them if they want a court-appointed attorney, and potentially screen them to see if they're eligible for indigent defense. In addition, the magistrate will determine if they are eligible for bail and bond and set that bail amount. These probable cause or show cause hearings are usually conducted at least once a day because, according to the Code of Criminal Procedure, in most cases, a defendant who is arrested without a warrant must be released from jail on bond no more than 24 hours after arrest if a magistrate has not evaluated probable cause. Further, according to the CCP, if a magistrate has not conducted a probable cause hearing, the bail is not to exceed $5,000 for a misdemeanor. If the person is unable to obtain a surety for the bond or is unable to deposit the money in the amount of the bond, the person must be released on a personal recognizance bond. So clearly, the CCP provides a very tight timeline for the government to get a misdemeanor defendant arrested without a warrant in front of a magistrate to evaluate the arresting officer's probable cause. If not, that defendant must be released on bail not to exceed $5,000. Further, if the defendant can't afford to pay that $5,000, the CCP states they are to be released on a personal recognizance bond, or only on their promise to appear. So it's typically in the government's best interest to get the misdemeanor defendant arrested without a warrant in front of a magistrate as soon as possible, but no later than 24 hours after an arrest. Similarly, in most cases, a defendant who is arrested without a warrant on a felony must be released from jail on a bond no more than 48 hours after arrest if a magistrate has not evaluated probable cause, and that bond is not to exceed $10,000 for a felony. If the person is unable to obtain a surety for the bond or unable to deposit the money in the amount of the bond, the person must be released on a personal recognizance bond. So clearly, in both cases, it's going to be in the government's best interest to get defendants arrested without a warrant in front of a magistrate to review the facts and circumstances surrounding the arrest and make a determination if, in fact, there is probable cause an offense was committed and the defendant committed it. The difference is that the government gets a bit more time for felony offenses and the max bail that may be assigned. Of course, the maximum amount of bail that can be assigned is negated if the defendant is unable to pay the bail, in which case they are released on a personal recognizance bond. In other words, solely on their promise to appear in court. There are a few exceptions to these requirements. In most cases, the prosecutor may request a magistrate postpone the release of a defendant arrested without warrant for no more than 72 hours without the probable cause being reviewed. However, an application filed must state the reason a probable cause hearing has not been conducted. Of course, This begs the question, if a prosecutor can get a hold of a magistrate to postpone the release of a defendant, why couldn't the prosecutor just have the magistrate go ahead and review the probable cause? The answer could surround a case where more time is needed to gather additional facts and circumstances to meet the probable cause requirement. However, it can be speculated this sort of instance would be rare and only for particularly heinous crimes. Finally, the Code of Criminal Procedure specifies that all of these time limits for release from jail on bond do not apply to a defendant who is taken to a hospital, medical clinic, or other medical facility before being taken to jail. The time limits begin when a doctor or other medical professional releases the person. In some cases, when a person is arrested, they may feign or actually experience a medical condition that requires them to be taken to the hospital. The CCP states in this case, the clock doesn't start ticking for the government until after they are released from medical treatment.